Good afternoon, fella.
Afternoon. What's going on, sir?
Not much. Okay, so my name is Josh Floyd. I'm an attorney at Jimenez Law Firm, and here we have the one and only.
James Diamond Pale and Senior.
There you go. Okay. So welcome to the consultation. We get together every Friday at noon and just kind of talk through some legal issues. People pose questions and we kind of go through different analysis on it to kind of give you guys insight as to how we evaluate cases and what kind of issues to look for, and hopefully give you a little bit of knowledge that you don't already have. We tell everybody, and we'll say at the beginning and hopefully at the middle if James reminds me, and at the end we'll say it, don't take anything that we say here as legal advice. We always recommend that you go to an attorney that practices in the court where your case is, that has experience in the field where you need help, and seek their advice, right? Because they'll be able to dive into more of the details and know the courts and that kind of thing. So don't take anything we're saying as legal advice, just kind of roundtable talk. We're just going to sit here and BS through some issues and give you what little bit of knowledge we have. Cool. All right. So, as always, follow us on all the social media platforms, Facebook, LinkedIn, TikTok, Instagram, Twitter. Is that everything?
Did you mention, what was the one you said last time? Tinder?
No. I think I might have gotten in trouble mentioning that, but yeah. So you can't find us on Tinder.
Right. Not me anyway. Happy to meet you.
We're specifically excluded from that. So with that, we ready to get rolling?
Yeah, let's do it. Let's do it. I'll read the first one.
All right.
Hearing before signing the order for a drug screen. In a Texas family court modification case, what is the procedure to request the other party be drug screened? What do you think?
So that really depends on the court, right? I'll say most courts, you would file a motion for drug screen. You would set a hearing on it. If the other party objected, they can hold a hearing to determine whether or not the court should order a drug screen. There are some courts that just always grant them, right? They like drug screens. And so a lot of times in those courts, you can just file a motion to order and the judge will sign off on it. But in the courts that do require a hearing, you may have to go to court and show why you're requesting right? That you're not just doing it to be a jerk or to waste this person's time or money or whatever. You have to show there's some basis for the request. And if you can do that, then generally you'll get one ordered. Most of the time, if you request a drug screen, you have to pay for it. So generally, if you request one from the other party, you pay for theirs, they pay for yours, type thing, if they want one from you. But sometimes it's different. You got anything else on drug screens?
Well, my question would be, is it always worth it? I know different judges take, different substances with a different degree of seriousness. So it might not be worth the money. So you're really going to want to get with an attorney who practices in your area, who'll be able to sort of spell that out for you, whether or not, a little bit of CBD or whatever it may be is even worth the hassle.
Yeah, so generally when the courts do test, they're doing 180-day hair follicle drug screens. I believe the experts say it goes back about 6 months. They take about 6 inches of hair, I think. We tell all of our clients, make sure you're clean for 9 months before we go take one, because we don't want to take any chances. But so generally it'll be 180-day hair follicle. So you've got to be clean for 6 months. And like James said, different courts view it different ways and have different consequences for failures of those drug screens. So yeah, it just kind of depends whether it's worth it. But if you don't show up and take one, then what happens, James?
Well, it's automatic positive, right? And depending on like I said, depending on the court, at least here in Odessa, that's bad news for you, and that's going to mean supervised visits for a long time.
Yeah, and whether or not to request a drug screen is a strategic call, right? That you really need to discuss the pros and cons of with your attorney before just jumping out and requesting one. It delays the case, right? So if you're set for a hearing and you request a drug screen, well, you're going to be bumped for a couple of weeks so you can get those results. So in your particular case, you may not want to delay it because of something that's going on. It's just various reasons why you may or may not want to do a drug screen. So it's kind of a strategic decision. So that's it. That's drug screens.
Yeah, I think hey, well done, Mr. Floyd. I think we hit that on the head.
Yeah, you think so? We tend to do that a lot better when Christina's not here, right? Because we don't just start going down all these paths that she takes us down, the yellow brick roads that she keeps taking us down.
I'm not familiar with that reference. Is that
the yellow brick road?
Is that Mary Poppins or?
James, we're on Facebook Live.
Okay, yeah, all right. Hey, I thought this was a place where we could ask questions, but that's okay.
Yeah, so it's a Wizard of Oz.
Never seen the whole movie.
You've never seen the Wizard of Oz?
No, sir.
I think that's going to have to be one of your assignments, James.
All right, I'll see about it.
So a lot of good moral values can be learned by watching the Wizard of Oz.
Yeah. I don't know if you're serious or not. So
no, I'm always serious. Yes.
Okay. All right. Wizard of Oz. I put it on the weekend watch list.
All right. I'll go to the next question. Ready?
I'm ready.
Okay. Okay. My son-in-law is a sex offender. He's relocating to Texas. Can he be around my children with or without adult supervision? I have 4 kids and each family comes over for dinner. Can the adult sex offender be here even if there is far more than one adult supervising their children?
Okay. Yeah, this is a tough one. So a lot of that's going to depend on if he's on community supervision or parole. If he is, then they're mandated not to be involved with any children, involved in any minor activities. That's going to look a little bit different if he is not on probation or parole. And a lot of that's going to depend on municipality, right? So there are some general Texas guidelines for sex offenders, but you're going to want to check with your city. But without those details, it's going to be kind of hard to say but specifically if he's on community supervision, then that's a no-go for sure.
Yeah, so if he's on probation, like I said, generally they no kids, right? But there's usually, what do they call them? The people that are authorized to supervise, they're specifically listed out in the probation terms. They've got a special name for them, I don't know, but there's usually people that have been approved by probation to supervise, right? So just the fact that there is adult supervision would not satisfy the probation term requirement unless the adult is the person that's specifically authorized in the terms of probation. But if he's not on probation, then generally speaking, a sex offender can be around kids, right? There's no registration requirements or anything like that that will prevent them from being around kids absent some probation term or something like that. Now, from a family law perspective, right? So I think she's asking about legally, right? Can we get in trouble for it? I don't think so, unless he's on probation, right? But is it a good idea?
Yeah. There was a comedian who has now since passed, but he made the joke that being around temptation is like being a bear with fish walking around, and those fish are dipped in honey, right? So, not to make a direct comparison, but if this person is the bear, and you see all these fish walking around dipped in honey, a bear is going to be tempted. So why put the bear in that position? See what I'm saying?
Yes.
Hey, I try not to get political on here, but
Yeah.
I don't think it's a good idea either.
Yeah, I don't think it's a good idea. Well, I think it depends on a lot of how old we're as victims, right? So registered sex offender could mean anything, right? It could mean they, molested a 3-year-old child, or it could mean they were 19 and had sex with a 16-year-old girl, right? It could mean anything.
Yeah.
So what are we talking about as far as a sex offender? So if you've got somebody that's molesting a 3-year-old child, I think that's viewed a little differently than somebody that was 19 that had sex with a 16 or 17-year-old girl, whatever it would be, right? I mean, but they still get the same tag.
Yeah. I don't know. I think she was pretty specific. I mean, can the adult sex offender? But yeah, you're right. They get the same tag.
Yeah.
You get the same tag.
Right. I mean, in indecent exposure, right? On your second indecent exposure, you registered as a sex offender. You haven't diddled anybody. You just showed your stuff, right?
That's not okay though.
I didn't say it was okay, but it's different than messing with.
It's different, but you're a flasher.
What?
A flasher.
Right. So you may be subjecting yourself to some flashing if you invite them over, right?
Right. Yeah. Do you want to expose the kids to that? I mean, do you take the chance? You gotta, self-assess.
And if you are frequently allowing, so if this was a custody case, right, or a family law case or whatever, and someone came to you and said, hey, the mother of my children is allowing this registered sex offender, to constantly be around the kids.
Right.
How's that play out?
That just sounds bad to anybody listening. And
generally speaking, if you request an injunction or an order from the court, rather, to prevent the kids from being around somebody that's a registered sex offender, that will get granted.
Right. We're not even talking about morality clauses.
Yeah. So from a family law, child custody perspective, not a good idea for sure to have children around sex offender, especially if their victims were children. Never good.
Agreed. Let's see. Next question.
Sure.
All right. When your case with child custody gets dismissed, does your temporary custody agreement end? I have a family violence case open, but got dismissed today and need to know if the agreement ended. So it sounds like there is a criminal case and a family case.
Yeah. So when your case with child custody gets dismissed, so I guess his custody case and the family violence case got dismissed? Or is it a custody case that's alleging family violence?
Family violence case open.
The answer is yes, right? If you've got a child custody case and there's temporary orders that were entered into during the pendency of that case, and your case subsequently gets dismissed or non-suited or whatever goes away, then the temporary orders go away with them. A lot of courts will put cases on what they call the DWOP docket when they've been hanging around too long. Dismissed for warrant of prosecution is what it stands for. And basically, because you haven't done anything, they put you on the DWOP docket. And if you don't show up to the DWOP docket or don't do what you're supposed to keep the case on the docket, the judge dismisses your case. And so we see that happen, where there's temporary orders in place, they get placed on the DWOP docket, case gets dismissed, and those temporary orders go away. And now all of a sudden you go from, having an order where it's set out, child support, visitation, conservatorship, all that stuff, to now there is no court order that would that would guide you through what you're supposed to do. And so that could cause a lot of problems.
Right. Yeah. So now it's back to the Wild West. And so if we can explore a little further, I mean, what would you advise this person?
Which road do you want to go down?
Let's go. Everything got dismissed, right? Right. Got dismissed. And now there are no orders. So how are me and my significant other supposed to co-parent?
You're supposed to act in the best interest of your child.
Right. And I think it's in the best interest to keep the kid and, you know, not communicate.
Yeah. And you're gonna have to justify those actions to a court one day.
Right. Okay.
Which is maybe where you run into a problem.
Right.
If it were my client, they came in and said, hey, this is what the order was. It got dismissed on a DWAP docket or whatever. We didn't intend for it to get dismissed. How should I behave? I would probably tell them, behave like you were before, right? Follow the prior order. You know, now if circumstances have changed and, you know, that's no longer practical, then we have to deal with it. But I would say my first answer would be, let's keep it all the same. But his family violence case openly got dismissed. So I guess they're alleging family violence in this custody case, right? What impact does that have on everything?
Big. I mean, that's going to impact your ability to mediate. That's the biggest thing, at least that stands out, because mediation is how a lot of things just get done without having that ultimate drag out, tooth and nail fight at the final hearing. So that's one huge matter. And then you lose a lot of leverage when the other party's in front of the judge saying you used to beat on them, right? Particularly if it's in front of the children. So just as a general rule, everyone should keep their hands to themselves, treat each other with love. But the fact that this got dismissed, I mean, that's great for you in your case. But it would be wise for you to do as Mr. Floyd said and do your best to keep things relatively civil and adhere to the orders as they were, unless you were like, well, and this is, let me ask, unless you're paying crazy amounts of spousal support. And I mean, in that case, would you still advise client to continue with the status quo?
Probably not. I think it depends on how long the temporary orders have been in place, you know, how long you've been paying spousal, whether they've attempted a good job. You know, you don't ever want to leave them just high and dry, right? Maybe wean them off of it or something. I think it depends on the circumstances. But I do want to point out something you said earlier, which is just generally good advice for anybody listening to this, especially my wife, Rochelle. You know, do as Mr. Floyd says, right? That's what you live your life by.
Yeah, okay.
I thought that was really wise advice, James.
I thought you were going to say something else, like the mediation and the family violence. Should have known.
We have a question. Father has no contact with child for more than 3 years. Can mother have his rights assigned away?
Well, you could ask him if he wants to voluntarily sign his rights away. You could go another route. But when you say sign, I'm assuming you are requesting for a voluntary termination. And he may be up for it. I mean, you know the circumstances better than we do as to why he's been away and why he hasn't been in contact with you all. So he may be up for it. It's that part's going to be his decision if he decides to sign.
Yeah, I think we touched some on, I think actually we talked a lot on termination last week, right? And how difficult involuntary terminations are. So what James is talking about is if he voluntarily signs, right? But if he doesn't want to voluntarily sign, right? And you want to move for an involuntary termination, the code's very specific on the grounds upon which a involuntary termination can be granted. Was there like 8 or 10 or something like that? I don't know the exact number, maybe 13, I'm not sure. But yeah, so she says he refuses. So he doesn't want to. So you're gonna have to go involuntary termination. he has back pay for 7 years. So he hasn't paid child support for 7 years. So involuntary terminations in Texas, very, 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 very difficult, because your parental rights are basically buried in the Constitution, right? And so they don't interfere with parent-child relationships unless it's something pretty extreme. If he hasn't paid support in 7 years, there is a ground upon which you can request an involuntary termination. His failure to provide support in accordance with a lawful court order for a period of 12 months. 12 months have to be consecutive, right? So it's if he went 11 months and made a payment, and then went 11 months and then made a payment, right? Then you would not qualify. But the difficult part is, in order to get the voluntary termination, you've got to go back through each one of those months and prove that he had the means to make the payment and just didn't do it, right? And then even if you're able to do that, right, you're able to prove that he did not provide support, had the ability to do so for a period of 12 consecutive months, then you have to prove by clear and convincing evidence that it's in the best interest of the child for this father's rights to be terminated. And that is difficult.
Yeah.
Judges do not like to do those. So yes, you can request it. There are other strategies we can take, right, that might help him with his decision to relinquish.
Careful choice of words there.
Yeah. I'm not going to pull the CJ and just throw it all out there for everybody, but so you should definitely contact an attorney in your area, because there are things that can be done to entice him to do what needs to be done. So
encourage. I like the word.
Encourage. That's a good one. Yeah. Encourage him to do the right thing.
Yeah.
Okay. So is it my read?
I believe so. Yes, sir.
Okay. Will it be illegal for me, a 14-year-old, to get a tattoo in a different country where it's legal and then go back to Texas? I have parental consent and I'm visiting a country where it's legal to get a tattoo, but I will be going back to Texas where it's illegal for a minor to get a tattoo there. Will it still be okay?
Oh man, and I get it, man. I mean, it's funny, the kids these days crazy tatted up, man. You like the Island Boys? Have you seen them?
Mm-mm.
Yeah, man. Floyd, you got kids, man. You gotta get with it.
Now I'm gonna have to look them up.
Yeah, the Island Boys.
Wizard of Oz. I don't want to hear anything about me not seeing.
What did it come out in the 60s? Come on, man.
I think he did a remake.
Okay, more or less. Okay. Or hey, you want thug life across the belly like Machiavelli? I get it. So yeah, I mean, in this countries like I think Costa Rica, you can go get a tattoo. It's not illegal to have a tattoo. It's illegal to get a tattoo by falsifying your age. So if your parents are with it, yeah, kid, express yourself, but you should know that there are circumstances that you can get a tattoo legally in Texas while you are a minor. And it's when your parents don't like your tattoo, basically. So they can take you in and represent to the tattoo parlor that they are consenting, and then make you get a cover-up of that thug life tattoo. So, but as far as you getting it somewhere else and coming back, I don't see why not.
So he said that, and we don't really know anything about this, right? We don't deal with illegal tattoos, but so he said, when he gets here, will it still be okay, right? So is it illegal to obtain a tattoo in Texas or illegal to have a tattoo?
It's illegal to obtain one. Like say you're from Canada or Costa Rica for that matter, and you move to Texas, there's no one gonna charge you or prosecute because you have ink,
Right. And is it a law that they can't get tattoos, or is that like an ordinance, a licensing?
No, it's a law. I think it's
Is it Texas Penal Code 23.004? You think?
I don't have it in front of me.
Completely made that up. I don't know.
Okay, boy, just talk without statutes. What are we doing? What are we doing? But no, I know it's health and safety hazards. It's in the tattoo laws, right? Licenses, tongue piercing, it's the whole section. But the issue isn't having the tattoo, it's falsifying your age to get a tattoo.
Okay.
He's not in jeopardy of doing that. Did you look up the Island Boys while you at it?
I did look up the Highland Village, yeah. And I also looked up Wizard of Oz was made in 39, right? So you've had
Okay, yeah. So
80 years to see it. There's no excuse.
all right.
Okay. Read.
All right, it's on me. What can I do legally if a Texas CPS worker lied in her statement to the point where my children were removed 2 weeks ago? We had nothing, not one bruise, not one hurt in any way, nothing. The person got upset and called the police on my husband, and now we're having to deal with something that's all a lie. I don't want to go through this. Help.
Okay, so she's saying CPS lied?
CPS worker lied in her statement to the point to get my children. So it sounds like they're going through the removal process, and somebody, a foe, an enemy, if you will, called them, and yeah, now she's in the process. I don't know.
So I guess I'm confused on how CPS would lie if they don't know, right? They're relying on what somebody else has said, I would assume. It's generally what happens, right? So let's attack it on both fronts. So if you have a CPS caseworker that is falsifying statements, that is not very nice of them.
Right. Agreed.
And so what we would do is gather evidence to prove that they're lying. And hopefully we can do that. Because 9 times out of 10, the courts are going to take CPS caseworker's word over yours if it's he said, she said, right? Because the CPS caseworker is supposed to not have a side and not have anything to gain, right? They're just there to protect the kids. Whereas you, as a parent of the child, have something to gain because you don't want to lose your kids. Right. So the only way you can do it is if you have some type of proof that they lied. And we've caught them, right? Doing things that they shouldn't do, saying things that didn't happen. And the courts frown upon it. So what can you do if it's a CPS worker that lied? Do some investigation, right? Hire an attorney that will put the time, put the work in to establish what you're saying is true and what the CPS caseworker is saying is not true. And then go get your kiddos back. Now, for the one that happens more often than that is someone lying on you and calling CPS with false allegations. What do you think about that stuff, James?
That's not very nice either.
Agree. No, it's rude.
In fact, I'd say it's mean. But in those situations, usually you have an opportunity to speak with CPS, which is hit or miss. A lot of times people get nervous. And when people get nervous, they just start talking sometimes and they say the wrong things, they say too much, and they get themselves into trouble that they otherwise would not have been in.
So this is a big problem that we deal with in child custody cases. It shouldn't be a problem because people should not do this, but it is. It's a huge problem, right? I mean, frequently one parent or the opposing party's parents or boyfriends or whatever will call and make false allegations to CPS about the other parent to gain a strategic advantage. Because if there is a CPS report, it automatically raises the judge's eyebrows, right? Because judges, first and foremost, have to protect the kids, right? And so if there's a CPS case pending, judge wants to know the outcome of that case, right? And so it does, for a temporary period, give them a strategic advantage or an upper hand. But once we're able to establish that you lied about it, it has quite the opposite effect, right? And there's also a criminal offense, right, for filing false reports with CPS. I don't know if I've ever seen it prosecuted. I've tried on several occasions to get it prosecuted. I don't know why it's not prosecuted more often, but it's certainly an abuse of the system. It runs the other parent through a bunch of crap and the child a bunch of crap that they shouldn't have to do due to these false allegations. I think it absolutely should be prosecuted when it happens.
And there's also good news, though. There's good news. So say you're in a position where, like the person who asked the question, you're in a position where someone has lied on you, and you do the investigation, you hire great attorneys, and the report comes back unfounded. You can get that removed. You can get that removed, and it's not going to stick with you if you go through the proper steps. And so there is justice at the end of the tunnel. It's just kind of an inconvenience, extremely frustrating circumstance when someone feels like they have to do that to the other
especially
person.
when they rip the children from you, right, and place them in foster care.
Yeah.
It's terrible, 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 terrible.
Yeah.
But even if they find that the case is ruled out, meaning the allegations are false, right? Like James said, you can have it removed, but even if they RTB it, reason to believe, right, which is basically they believe the allegation is true, you can still contest that, right? You can go to a hearing, an administrative hearing, and argue the evidence as to why it shouldn't have been a reason to believe finding. We were successful on one of those cases on a child neglect. So you can fight it. You know, you're fighting the system, right? You're fighting the man. So it's difficult, and everybody generally believes what CPS says. And I think CPS was founded for a really good purpose. And there's a lot of really good people that work there. There's a lot of lazy people that work there too, unfortunately. So it is what it is. Don't do it. It's rude.
Yeah.
And we don't want to be rude. I know.
Wow.
But of course, I don't want you to take that as legal advice, right? Because nothing we're saying here should be taken as legal advice.
Exactly.
Right. You should, seek the advice of an attorney that practices in your area and that might know a thing or two about these kinds of issues. So.
And while you're doing that, follow us on social media.
Yeah. Which ones are we on?
We're on Twitter. We're on Facebook. We're on LinkedIn. We're also on Instagram. And yeah.
That it?
Snapchat, possibly.
Really?
Hey, it's possible. Keon, you're watching. So look,
I've never used Snapchat. Don't know anything about it.
Plausible deniability. I like it, Floyd.
That's what I do. Okay, you ready?
I'm ready. Yeah.
What can I do as a father with shared custody? My daughter was 16 having sex with an 18-year-old boy while under her mother's care. She came out pregnant. She just turned 17 and now the boyfriend is 19. Is there anything I could do if I had no knowledge of any of this happening until I found out she was pregnant?
Yeah, that's interesting set of circumstances. So, I mean, we talked about it earlier with the sex offender. That's going to be 3 years. So as far as criminal prosecution, that's out the door. I mean, I don't know if they're still together. You could always look to establish child support, conservatorship, possession and access. And then, there's a third option. Floyd was talking about back in the 30s. Back in the day, someone might get a 12 gauge defender, find a local priest, a wedding DJ, and you got yourself a good old fashioned ceremony. Outside of that, your hands might be a little tied here, sir. But what do you think, Mr. Floyd?
So I think what you can do is love your daughter, support her, and be really happy to have that grandchild coming in.
There we go.
And just really enjoy the life that you guys are going to have together and the time that you're going to have with that grandbaby. And have a very stern talking to boyfriend. And, you know, if he sticks around after that, he probably deserves it, right? If he doesn't, well, then he has to suffer the consequences of that, whatever those may be. But
what are we talking about here, Floyd?
We were talking about a 12 gauge Defender.
That's a shotgun wedding, right? Come on, man.
I was talking about a shotgun too.
Right? No. I mean,
I thought we were on the same page here, James.
No, we missed each other.
Okay. Would that not be? Would that not be defensive of third person or anything like that, or no defensive?
We'll have to talk about that, Mr. Floyd.
Okay, well, let's just love the baby.
Yeah.
Prosecution. Choose love, not war.
That's it. Okay. Yeah. Bueno.
Yes. Roll on.
Okay.
Am I up?
Child support refund. After paying child support for a few years, a paternity test was done showing that I wasn't the father. Can I go to small claims court and sue for a refund? What do you think, Mr. Ford?
I think, unfortunately, I can't. Well, I don't actually know, right? So if there's a court order, then he's adjudicated the father, which means he admitted to paternity because there wasn't a genetic test done before. So he admitted to paternity. I don't think you can overturn the adjudication of parentage at all. No, I don't think you can. I'm sure somebody will jump on here and correct me if I'm incorrect, but I really you can't. It just acknowledged or presumed, I think you can overturn, but I think once you're adjudicated the father, you are the father. I think you had your opportunity when that case was pending to get the genetic test and all that stuff. I keep wanting to say there's got to be some fraudulent basis for you to be able to do that, but I think if you had no reason to doubt it, for some reason I'm thinking adjudication, you can't do it. But
okay, so I'm sorry. Essentially what you're saying, after he has, okay, let's say it was presumed first, right? He signed the birth certificate.
Okay. So he's acknowledged, and so they're married, so he's presumed also.
Right.
Okay.
And then later on, for some reason, I don't know what made him get the paternity test, but he got one. So you're saying that, yeah, you have to bring that back. You have to bring that back.
So he's saying that there's a court order for child support, right? So in order for there to be an order for child support, there has to be a finding of parentage, right? Which would then make him an adjudicated father, right? So the court has now adjudicated him to be the father of this child.
Mm-hmm.
If you're going to request a paternity test or challenge paternity, that was your time to do it, right? And if you fail to do so, I think you're stuck like Chuck.
Oh man, that's horrible.
I think that if you're an acknowledged father or presumed father, under certain circumstances, you can challenge it before you become an adjudicated father. But I think once you're an adjudicated father, you're done. Say there may be some fraudulent exception that I'm not thinking of right now, where if you had no reason to believe that you weren't the father or something like that, you might be able to do it, but I don't think so. I think once you're adjudicated the father, you is the father. And if that is the case, then you're also on the hook for child support for the rest of the child, or until the child turns 18, and you would not be able to go back and get the money back. Maybe could be some type of civil suit you could file under some type. You got this, right? IED.
That's it. Hey, you already know. You already know. Tort,
Yeah,
trespass to chattel.
we'd have to go there.
Hey, that's cold.
Um,
Man, that's horrible.
so I don't think so. I don't think you can. I think once you've done it, you're done.
That's something I need to research.
But what if you paid support? What if you were a presumed father, right? So you're married. Well, let's just say acknowledged father, right? So you're led to believe that the child is yours and you sign the birth certificate and you guys are separated. You pay support on your own without a court order for several years, let's say 2 years. And then you take a genetic test and find out that you are not the father. What about then? Can you get the money back?
That's a great question. I don't know.
I don't know either. I think you would have an argument, right? There's also argument that it's a gift, right? You should have done the paternity test before. Then it's fraudulent. So I think maybe it depends on the facts. I'm not sure.
Yeah.
Yeah. Let's move on and talk about something we know about. You do that?
Deal.
Why was I taken to jail for violating a protective order?
Well, it's right there. Next question.
I was at my daughter's birthday party, which was held at her great aunt's home. My wife has a protective order against me. We had an argument and the police were called. I went to jail for violating the order. But it states in the paperwork to stay 100 yards away from the residence, job, and school, but it's not her residence. ...
Right. But also, does it say you have to stay away from her? I probably bet you have to stay away from her. Doesn't say HEB, but if you run into her at HEB, you can't sit there and have it out with her.
Yeah, so generally it says, it'll specify, their residence located at blah, 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 their job at blah, 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 the school, blah, 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 or any other place they're known to be, right? And so I always tell my clients that if you go somewhere and they're there, leave, right? But certainly when you got into an argument, man, it's time to roll out. She's already got a protective order against you.
No, this is my grand aunt's house.
Nothing
I have
good.
right to be here just like you do. You know how it goes.
Yeah, no, I get it. And I guess the police officer showed him they didn't have as much right to be there as she did.
Right, unfortunately. Okay, well, that's why you went to jail, sir. So try and stay away. I wish you well in your future endeavors. Next question.
That's it. That's all you want to talk about? Let's talk about protective order.
Okay, yeah. So how did she go about getting this protective order on you? Perhaps there was some family violence between you or the kiddo.
So to get a protective order that you would have to show was really one of two ways, right? Family violence plus a future threat, right? That would occur again, or stalking protective order. So there's been something shady there already with the protective order. The protective order is good for 2 years, generally speaking. There are exceptions, but generally speaking, 2 years. And you're not allowed to violate them. That's against the law.
Yeah, you're gonna go to jail.
Right. Okay. Protective orders, I don't really want to talk about. They're boring. Can you go something else?
I want to get back on that child support refund, but we have other questions. Let's see.
Well, do you know the answer?
No, I don't. I thought maybe we could spin it around a couple of times because, I mean, in my experience, the practice of law usually follows a logical basis, right? They're just,
we must practice different law.
I mean, yeah, jokes, but there are very few, at least in my opinion, just arbitrary laws that seem to be for no rhyme or no reason. Okay, now this one, if he is unable to cease paying child support, and he's also unable, and right, yeah, he has to continue to pay child support for a kid he knows is not his for the duration, and he's not entitled to any sort of refund. I think that is a failure from the legal department. because, most people in his position are not going to know that they, they probably, hey, look, you're the kid's father. I need child support. All right, cool. Through the attorney general. I have work to do. I have life to live. This isn't my everyday. So for him to get got like this, it's almost criminal.
Yeah.
Right now.
Yeah, I was trying to look up to see. Yeah, no, I get it. Right? I mean, because if he had no reason to believe that he wasn't the father, then he would agree to the order or for child support, trying to be a good father. And then to later find out that he's not.
Especially if they're married or something, right? What's that, 300 days? 300 days before the birth of the father or of the kid. If you're married, you're already assumed the father. So, the relationship fizzles. Yeah, these some tough facts. Inquirer, I will research this over the weekend. We'll figure this out.
Yeah, I don't know if people want to sit here and watch this research.
Right.
But all right, so let's go to the next question.
Okay. Are you reading it or am I reading it?
You read it. I think I just read the protective order thing.
Okay. Is a relocation hearing necessary, or what would our options be? I have the exclusive right to designate residency without regard to location. I'm selling my house and considering moving out of state to be closer to family, and because the possessory conservator intends to relocate to the Dallas area by the end of the year. My original plans were to move to Lubbock for my job, but Oklahoma City would put me closer to my family and only 3 hours from the possessory conservator. Instead of 5 hours away, we would be in Lubbock. Long story short, long story long, the possessory conservator agrees with the relocation and is willing to put it into writing. So my question is a relocation hearing necessary, or what would our options be? Would it have to be done in Midland court, or does it even matter?
This one hits close to home, right?
Yeah.
So you have the exclusive right to designate the residence without regard to geographical restriction, which means you can move anywhere that you want. It does not matter. If you want to move to Canada, you are welcome to move to Canada, or Nebraska, or
Idaho,
any place on earth that's much better than Oklahoma City.
Costa Rica.
Yeah. So a geographical restriction is generally imposed, right? And so basically what that is it's a court order saying that the child has to live within a certain area. The courts do that because it is public policy of the state of Texas to ensure that although parents are separated, that both parents maintain close continuous contact with the child. So generally there is a restriction placed on the child's residence where the child can live. In your case, it did not happen. It's very rare, especially in the Midland court, that a geographical restriction is not imposed. So yeah, you don't have to do anything. You can move wherever you want. It doesn't matter where possessory conservator lives or what he says or she says, whatever it is. I would say you need to roll out PDQ before he does file something, because you might get stuck.
Hey, Mr. Floyd, what's PDQ?
Pretty damn quick.
Oh.
So it is possible if he wanted to prevent you from moving that he could file a modification and seek a geographical restriction. And frequently those are imposed. So if you have a desire to relocate to Oklahoma City, do so quickly before he files anything. And you're fine. You do not need a hearing. He does if he wants to keep you there. You don't to move, because the order already says you can live wherever you want. So
sounds like you followed our previous advice and hired local counsel. Got you what you needed.
Yes. Yeah, that's not something that's done very often, especially in Midland. There are a few courts, most courts will implement the geographical restriction. There are a few courts that won't change them absent some very, very extreme circumstances. The courts are all over the board on what it takes to change them. We do a lot of work in Midland, so we're familiar with those judges. Those are one of the courts where it takes a lot of work to get the geographic restriction removed. So take advantage of not having it, kiss your old attorney, and head to Oklahoma City. No kissing the attorney?
Yeah, I think a guy in San Antonio got in trouble for that. Kissing his clients. Oh, yeah.
Yeah. Well, he kissed them, right? I'm talking about the client now.
Yeah, say, man, it's a fine line. It's a fine line.
All right. We got time for one more.
Yeah, let's do it.
I applied for child support over 2 months ago. Still haven't heard anything back. Putting my child's father on child support because he doesn't help with his daughters. I want this in place ASAP.
Well, ma'am, so I'm assuming you applied through the Attorney General, and they do their best. You know, they have attorneys and they're here to help you. And, you know, Mr. Floyd already went through the steps establishing paternity. You got to get a court order. You got to collect this child support. If he doesn't pay it, you have to enforce it. It's a process. So we'd ask you to be patient. If you're not going to hire a private firm, sometimes you may have to wait just a little bit. But they do get the job done, and they do a good job. You know, a lot of AG attorneys out this way.
There are a lot of AG attorneys that are good at what they do. But you have to remember that their interest is solely the state's interest, right? To make sure the state's protected, to make sure that the child's not placed on any type of government assistance when there's somebody that could be paying support. And so they will help you get child support. They will help you get medical support. They will not argue conservatorship or possession access or additional injunctions or any of that other stuff that most private attorneys will do to make sure that you get done what you need to get done. They're good at what they do. They do work for the state. It does take them a while to make things happen. So it's kind of one of those, you get what you pay for, right? You're not paying them. Right. So it's really hard to complain on it. But if you hired a local attorney that was experienced in this area and knew what to do, things happen quicker. So before we roll out, I do want to go back to this question we've been talking about because I think I found the answer. So pursuant to 160-637, any party to an adjudication of paternity may challenge the adjudication only under the laws of this state relating to appeal or vacating the judgment.
Okay.
So you can come back and take a paternity test. Yeah, if you're a party to the adjudication, you're bound by it.
Wait a second. Can you give me that one more time?
160-637. So, yeah, if you're going to challenge it, you got to do it before you're adjudicated the father. That's the way that it works.
Right.
Because otherwise, you can be paying child support for a child that is not yours. So, anything else? You got any plans for the weekend?
What am I doing? My brother's coming in town, so that'll be fun.
Cool. All right.
Yeah.
Well, it is 4th of July weekend, so everybody be safe, have fun. I guess before we go, I should do the little disclaimer thing here. Because we did say it at the beginning and I did get it in the middle without being reminded. And so now we will say it here at the end. You know, everything we said here today should not be taken as legal advice, does not create an attorney-client relationship. We're just sitting here talking about various issues that arose or that arise during family cases and tattoo cases or whatever questions you guys ask, and kind of our experiences with them and our thoughts on them, but is not legal advice. You are always encouraged to hire an experienced attorney in the area where you live, experienced in the field of law, where you need help, seek their advice, rely on what they tell you, because that is legal advice. This is not legal advice. This is just us chatting it up, right? So with that said, is there anything else? Follow us on Facebook, Twitter, Instagram. You have something else, James?
LinkedIn,
Snapchat, maybe Keon, I don't know. James threw it out there, not sure.
we'll see.
Is that it?
Yeah, I think that's it.
Okay. Well, you guys have a happy and safe 4th of July weekend, right? Go in and celebrate. Be careful. Have fun. Shoot off a lot of fireworks.
I know a guy.
I have no special interest in you shooting off a lot of fireworks.
You're right.
But yeah, blow them up. Have a good time. Be safe.
Y'all take care.
All right, dudes.